this court is so busy, I hadn't had a chance to even get on Santa's lap to talk to him about what he needs to bring this year.
That's shitty. That is.
All right, let's get to business here.
This is not just another probation hearing, this is a warning sign. A defendant already on deferred probation for choking a family member is back in court just 3 months later, accused of doing it again. Same behavior, same violence, different victim, and now, the court is forced to decide a terrifying question. Can this man be trusted outside a jail cell? What unfolds next isn't just legal procedure. It's a raw breakdown of patterns, accountability, mental health, and the thin line between second chances and public safety. As the judge reviews a growing history of domestic violence, every word matters, every pause carries weight, and one ruling could mean freedom or prevent the next victim. Watch closely because this case turns fast, and the consequences are deadly serious.
Michael Barrero.
Yes, sir.
And this is clause number 24 CR 687. And in this case, there is a motion to revoke probation that's been filed. It was filed on September 19th, 2025. And in summary, as you probably know, but for the record, this states that on June 19th of this year, God bless you, you were placed on 6 years deferred or unadjudicated probation for the offense of assault on a family member. And let's looking at that indictment. Said intentionally, knowingly, or recklessly causing bodily injury to a member of your family, household, or person with whom you had a dating relationship by pushing that person down with your hands, and you didn't intentionally, knowingly, and recklessly impede the normal breathing or circulation of the blood of the victim by applying pressure on the person's throat or neck and blocking their nose or mouth with your hands against the peace and dignity of the state, signed by the grand jury foreperson. So that constituted a third-degree felony. So you were placed on probation June 19th, 2025. Is all of that true and correct?
Yeah, yes, sir.
Okay. And raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. And once again, you were placed on probation in this court for 6 years deferred or unadjudicated probation for assault on a family or household member by impeding breath and circulation, a third-degree felony, and you were placed on probation June 19th of this year. Is all of that true?
Yes, sir.
Now, we have didn't take long. There's a motion to revoke unadjudicated probation that was filed September 19th, which would have been exactly July, August, 3 months after you were placed on probation. Number one, it states that you committed the offense of assault, family or household member by impeding the breath or circulation on or about August 4th, 2025 in Hardin County, Texas, in violation of condition 1 of your deferred or unadjudicated probation order. Do you understand what you are charged with here, sir?
Yes, sir.
Do you? He says yes for you, but is that true? Yes?
Yes, sir. Yes, sir.
Okay. Then number two, and this says this is in violation of condition 1 of your probation order, which is do not commit another offense against the laws of the state or any other state or the United States. The second allegation states you committed the offense of interfering with emergency requests for assistance on or about August 4th, 2025 in Hardin County, Texas. And that must have been something arising from this other incident in violation of condition 1 of your deferred or unadjudicated probation order. Where is that found, that crime?
The impeding or are you talking about
that one? Interfering with request for assistance.
It's in the.
Is it in the penal code or in
That's in the penal code.
Okay. 42.062, interference with emergency requests for assistance is exactly what was alleged here. An individual commits an offense if the individual knowingly prevents or interferes with another individual's ability to place an emergency call or to request assistance, including the request for assistance using an electronic communication device in an emergency from a law enforcement agency, medical facility, or other agency or entity the primary purpose of which is to provide for the safety of individuals. An offense is a Class A misdemeanor, except that the offense is a state jail felony if the actor has previously been convicted under this section, which I don't think that's what he was convicted of.
Yes, sir.
Okay, so do you understand what you're charged with in allegation number 2?
Yes, sir.
Yeah, speak out. Okay. What are we doing today?
Bond hearing. Yes,
Is that right?
Yes, sir.
What's his bond line now? No bond?
No bond because he was transferred from Hardin County to here. You wanted to have.
All right. It's your motion. Go ahead.
Your Honor, I guess we'll just start with, basically he's on deferred, so his.
Okay, I know. You have
Here's what I
data or testimony to present?
No, sir, except that the allegations in the motion to revoke probation for the probation that he's on, he is entitled to a bond. Here's what has happened, if I may proffer. In Hardin County, he's been in custody since September. He made bond in Hardin County and they put terms and conditions of release on him. So he already has a monitor. In fact, he's wearing that on his leg.
Mm-hmm.
He already has terms and conditions of distance. He already has terms and conditions of contact. He has of meeting terms and conditions. There may be a term and condition that the state requests. But at this particular juncture, we're respectfully asking for a reasonable bond, a bond at around $25,000. And I think the state has a request for a condition that they'd like the court to consider.
Don't tell me the victim in this case is the same victim in the underlying indictment. Is it?
No. The
A
underlying,
different victim?
it is a different victim.
States.
This is the
victim advised that her fiance, the defendant. Okay, this was the fiance.
Yes, this was a that type of relationship which ensued after he got on probation or
Okay,
while
and
he was on probation.
So the original,
Right after.
on the original case, he was placed on probation for. He was accused of assaulting the mother of his children. Is that right?
No,
No,
No, sir.
it says
just a girlfriend, but
it says as of the way their respective children treated each other.
No, sir.
Wait, well, the way it reads, what was the relationship with this first person?
girlfriend.
A different girlfriend,
Yes, sir.
but a girlfriend.
Right.
Okay. Go ahead. What else?
I guess that's what we're asking as far as bonding. That you uphold the terms and conditions that are already on him from Hardin County, which he has the monitor and everything else.
Who is there a probation officer?
No, Your Honor.
Does somebody have a pre-sentence report?
I do, Judge. I'll have to print it off, but if you're looking for his priors or what was alleged in the pre-sentence report before,
Yeah, I want to see what.
I show in February 27th, 2022, he had committed an offense of assault causing bodily injury to a family member, was given 1 year deferred probation on November 15th, 2022. And on November 21st, 2023, he committed this offense that he's on probation for. So it was just shortly after he got off probation on the misdemeanor.
So this is going to. So this new allegation would be a third different assault on a family member?
That's correct, Judge.
Within how many years? Within
Well,
what?
2022 was the first one, February 27th, 2022.
Two, and then this-
Second one occurred November 21st, 2023. And then this one was was on probation for this. I think he was placed on probation June of 25 and committed this offense September 25. So if there is a bond, which I think under the deferred he generally is entitled to, but he's committed a felony while on probation for another felony, he would ask for an extremely high bond, at least $250,000 plus home confinement if he gets it, and no exceptions of leaving his home, not for work, not for anything other than seeing his lawyer.
Now, Your Honor, his family is here.
What did they have to do with any of the
Well-
alleged assaults?
Um,
That's what I'm worried about. The families, they're always going to be here.
No, the
Let me speak. The family. This is what what's annoying about it. They're here. Okay. This is the third assault in just a short period of time by a close member, a relationship, who has a relationship with these people. That's what I want to know is what's the family doing to keep that from happening? If they're not involved in the deterrence of it, I don't need to hear them. I really don't. Let me speak and finish.
I'm sorry, I thought you were. I apologize.
How can you do? I'm still speaking.
I'm sorry.
We can't, but we can't both speak. We can only
Okay.
take one at a time. But family assaults are the most dangerous and the volatile of them all, and that's why we're very sensitive about this. And this is, I mean, three uniquely similar situations, and he's putting when somebody puts their hands around someone's throat and squeezes, there's only one intent, and that's to kill.
Well, that is.
No, don't interrupt me. I'm still speaking. You're going to have a chance to respond. That's exactly what it's all about. You got to breathe, and when you prevent somebody from breathing, they're going to die. And that's in the underlying indictment. It's alleged in the indictment that he pleaded guilty to. Then we got, let's see, a prior conviction, you said, Mr. Laird?
It's prior deferred probation.
For what offense? And that was in 22?
Yes, sir. He was given, the offense occurred February 27, 2022. It was assault causing bodily injury family member. On November 15, 2022, he was given 1 year deferred probation. And then he committed.
What was the underlying facts of that? Does it show?
The first one?
What the assault, how the assault occurred?
Let me see if I can find that.
But while he's doing that, here's on this one, on August 5th, committed the offense of assault by impeding breath or circulation again. He's just, he strangles people. No. What do you do when you stick your hand around somebody's neck and squeezes? That's strangling.
That is your arm.
All right. He's done it twice, according to this. And then I want to know what happened in the first case of his first love interest. Man, that's just incredible.
We get to the probable cause, Judge.
Yeah. Just on a side note, you're getting it all wrong. You're supposed to respect and care for the people you care for and love.
Yes.
Not strangle them.
Yes.
Okay. I didn't know if maybe you didn't understand that, but you understand that clearly.
Probable cause as on Sunday, February 27th, 2022 at 3:16 hours. Officer dispatched to 1205 MacArthur Drive, reference to developments, possible assault in progress, called in by a juvenile. Upon arrival, officers on scene overheard a loud thud and upon entry found that the accused, Colton Barrera, was assaulting his living girlfriend of 1 month by throwing her inside the bedroom up against a wall multiple times, causing her pain and bodily injury. Barrera was observed to be intoxicated as the assault occurred after he had arrived home angry. Barrera was placed under arrest for Class A family violence.
All right, you go ahead.
Thank you. What I was going to say is that the families here, when they hired me, the very first thing I tried to do was get him civilly committed with a committal because he's been diagnosed as bipolar. Now there's extenuating circumstances and facts that are part of this new case. That's when his family came to me, and that's when I began to do it. I couldn't get it through the county judge to try to get that. Otherwise, that's where I was trying to get him back on his meds, back where he needed to be. And that was the whole process of them hiring me.
What medication are you talking about?
His medication for his bipolar disorder. He has major depressive disorder. Of course, he has ADHD, but
How long has he been on medication?
Since how many years?
Not taking it for probably 5 or 6 years consecutive.
Oh, wait. Okay. So whose fault is it he's not taking the medication that was obviously prescribed for his situation? Whose fault is that? Who's keeping him from swallowing the pills?
Right.
And who's doing that?
Well, his family has come in and tried to start do that. They tried to take a.
No, it's his choice, huh?
Well, yes, sir. But I'm just saying, as far as the family, where's the family going, and where is his support team? He has a support team. I tried to get him into Oceans. Oceans was considering taking him, which is a long-term treatment facility for mental illness and other disorders. I couldn't get the committal into MHMR or B&H in order to get from there to Oceans. And so that's where we are. When I asked the court for a bond, the court said no.
I'm asking, here's what I'm more concerned about. Is he competent mentally? Do we need a competency evaluation?
He's been able to speak with me.
Yes or no? On
No.
that? There's not a question about that?
No, sir.
So the choice is his. How do you prevent that? They can come in and help him all day long, but he's got to swallow. He's a grown up. When we're diagnosed with something, unless we're incompetent or unable to take care of ourselves, he's out there alone. He's or independent. And as long as he's independent, he's got responsibilities. When you're diagnosed and you have medication, you're supposed to take medication. If you refuse or fail to do that, that's your fault. And other people are getting their necks squeezed here. I'm sorry, the family can't do anything. He's the grown up too. Either he's competent. If he's incompetent and the family has to help do that, then okay. But he's ambling about as an independent human, and that has responsibilities to it. You've got to not harm anyone, follow the rules,
Yes, sir.
and give each person respect. Those are the three requirements. Don't earn any money, live peacefully, and give each person respect. Well, this is the third event of a similar fashion that's being alleged here on this court watch. And I've got problems letting him go out independently when he has had two situations here and is not acting independently with wise choices and responsibly. And we're not just talking about he curses at someone. He's squeezing people's necks. He's had a habit. He's got a history of that, which can cause death.
Yes, sir.
All right. There's
so-
a lot that needs to be done here, which is consistent pattern in just a few years that should have been addressed before this. But nonetheless, it's on my watch, and then I'm going to address it.
Yes, sir.
But we're going to do it responsibly and in a aggressive manner that moves forward. Because I'm not going to put another person who gets assaulted while he's on a motion to revoke on probation on my watch. They'd say who's to blame on the front page, and it'd be my picture.
Yes, sir. I understand. Now, some of this competency is based on what we did in the Hardin County Jail to get the doctor to see him and get him medicated and get his medicine to be here. So where he's at right now is medicated. The terms and conditions that the court has to put on him from home confinement, the monitor is already on him. He has the leg for that with all the other conditions.
He was told by his doctor to take medicine, right? He was told by his doctor to take medicine, right?
Okay.
And he's not doing it.
Well, he's been doing it in the jail.
No, did he? He's doing it in the jail now. But I mean, when he's in the free world, he made a conscious choice not to.
No, but he is medicated, has medication. So, I mean.
But doesn't it have to be imbibed, taken in, and swallowed?
It does.
That's and he's not doing that.
Well, he is
That's
doing
what
that.
brings him up here.
Well, he's doing that at this point, Your Honor. If you put it, if he,
Because you know why? Because he's in jail and they're forcing him down. It seems like that's where he needs to be to ensure that he will stay medicated.
that's not a forcible thing. He is voluntarily taking his meds. They've never had to do anything like that.
So he intentionally didn't.
He wasn't taking his medication, Your Honor. But as far as the ability to have bond, he's entitled to bond with terms and conditions that this court can put on him. And home confinement, taking his medication with his family. He's not living by himself. He'll be living with his mother and father until we get this resolved.
Anything else?
No, sir.
All right. I'm going to agree. He's entitled to a bond. $250,000 is the bond. If he posts a bond, he will be home confinement. He cannot leave except with someone from the family escorting him. He has to be with a family member at all times. And they can bring him to and from your office, to and from court, to and from the doctor. He has to have a GPS device so I know where he is at all times. And he has to take the medicine that he is prescribed that he doesn't seem to take. What other conditions is the state asking for?
Well, of course, there's standard bond conditions of no contact with the complainant, either directly or indirectly.
And can't have any contact with the victim, and that's in all cases. Now, are y'all ready for a hearing in January?
I think we would need to get discovery, but what about?
What discovery do you need?
Discovery on the case.
It's gonna be discovery on the new case that they have in Hardin County. They'll have to
How long is it? How long?
First, I heard you say you had an opening at the 1st of February.
Yeah, for them.
Do we have MTOP hearings first part of February?
That's, well, that was just one.
I didn't set one, did I?
Yeah, we set them when we are able to squeeze them in, and but when we do some dates on MTRP hearings,
Yes,
most MTRPs are not contested, but the ones that are contested, so you don't know how long it's gonna take. So we'll set it though in first part of February, and she'll let you know, okay,
Yes, sir.
when she can iron it out after the first of the year.
okay, that sounds good.
All right. What else?
I think that's it.
Is there, what's the status of this Hardin County case? What are they doing on it?
They're indicted, they're moving forward.
They are gonna
So,
indict?
yes, sir.
Well, do you know when?
They've indicted.
Oh, it's already been done.
It has.
Do you have a copy of that indictment? When did they do that?
I don't know who's to do though.
They did that,
Okay, so the grand jury deemed probable cause that he committed a crime.
yes,
Okay.
on, September, I don't know. I see that.
Was this it?
Yes.
This is the way they do it?
Yes. The discovery of all.
Hmm. Hey, do you have a copy of this?
Oh, what?
This indictment?
No, Your Honor, do not.
Can we make copies for everybody?
Yes, sir.
Because I want one, and the state ought to have one,
Yes, sir.
and then, thank you. Is he getting all his medicine? He's been diagnosed to.
Yes,
Okay.
we have aggressively pursued that avenue. I mean, that has been progressively pursued since day one. Just dealing
You're
with.
gonna have to figure, not to tell you what to do, but you're gonna have to figure what's failing here. The doctor's doing their part. He's gotta be doing his part. How are you gonna ensure that that's gonna be done is your test?
Yes, sir. And that was part of.
Because man, next time, shame on somebody else other than him.
Yes,
Somebody what in the world? How many times does this have to happen?
But there's a support team dealing with his medication.
It has to be effective. It has to do the job,
Yes, sir.
whatever it is. But failure's not an option here because he's looking at going to prison
Yes, sir.
unless the fact finder can be convinced.
Right.
Because all that comes up at a trial or a hearing of past misconduct, and it's too similar.
Yes, sir.
Everybody asks, what's the problem? We all take medicine to some degree, but we take it
I'm hoping to have.
like it's diagnosed, or else it's our fault.
Yes, sir.
Okay. Make sure here. I think this is yours. This is.
Thanks, sir.
Yeah, I got a copy. All right. What else to add right now?
I think that's it, Your Honor. We'll probably get with the state and deal.
This is where the courtroom temperature spikes, and for good reason. The judge makes something painfully clear. Strangulation is not just another assault. Legally, medically, and statistically, it's one of the strongest predictors of future homicide. When the judge says, there's only one intent, he's not exaggerating. He's stating a reality backed by years of case law and forensic evidence. The court also dismantles the medication argument. Mental health can explain behavior, but it does not excuse repeated violence, especially when treatment was knowingly refused. This exchange forces a hard question. Where does personal responsibility begin when someone repeatedly harms the people closest to them? And at what point does compassion become negligence?
with discovery. We'll go from there.
Okay, Brian, okay. All right. If something happens before this, let me know that we need to take up.
Yes,
That
sir.
might help you.
Yes, sir.
That you feel like I need to hear that can make a difference in where the orders are right.
Yes, sir.
Okay. What else? Anything else? Can you stay?
No, Your Honor.
We're recessed.
Thank you, Your Honor.
In the end, the court walks a razor's edge. Yes, the defendant is legally entitled to bond. But the judge makes it clear this is not trust, it's containment. A $250,000 bond, full home confinement, GPS monitoring, mandatory medication, constant family supervision, zero freedom without oversight. This ruling reflects the court's balancing act between constitutional rights and public safety, and it sends a loud message. Repeat domestic violence will not be minimized. The next hearing could decide whether this ends in rehabilitation or prison. Now we want to hear from you. Did the judge strike the right balance, or should bond have been denied altogether? If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.